And we are now continuing with these jury instructions. So we're on to retaliation damages, non-economic. Plaintiff is obviously Blake Lively. Defendant is Wayfarer or Ainsworth's Movie or Tag or a combination. We usually get a proposed instruction from each of them. Some rarely they have filed they put forward a joint instruction, and then we get maybe a proposed addition, and then we get their position. Then they might not take a they may not propose an addition. Then we get their individual position on why the other party's proposal sucks, why theirs is amazing. And that's kind of how this has gone along, just in case you haven't watched the other videos. Okay, so this is Blake Lively's proposed instruction. The following are the specific items of non-economic damages claimed by Miss Lively: reputational harm, as well as past and future emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future emotional distress damages, Miss Lively must prove that she is reasonably certain to suffer that harm. For future emotional distress, determine the amount in current dollars paid at the time of judgment that will compensate Miss Lively for future emotional distress. Now, if you watched part 3, you will remember that Lively is trying to, after dismissing her own intentional infliction of emotional distress claims, because she didn't want to allow Wayfarer any discovery, i.e. access to her medical records. She was told she could claim garden variety. She is now trying to kind of, through the back door, say, well, I'm entitled to emotional distress for the breach of the contract. And when Lively's talking about for future emotional stress and compensating those damages, that is, she's seeking more than just garden variety. But the contract rider, she's saying, well, the contract says I can do this. The contract did not say anything about emotional distress. Okay. Defendant's proposed instruction. The following are the specific items of non-economic damages claimed by Miss Lively. 1. Past and future garden variety emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. However, garden variety emotional distress damages generally range from $5,000 to $30,000. To recover for future garden variety emotional distress damages, plaintiff must prove that she is reasonably certain to suffer that harm. For future garden variety emotional distress, determine the amount in current dollars paid at the time of judgment that will compensate plaintiff for future garden variety emotional distress. Now, Lively has a position on this. Instruction restored, as it is critical to instruct the jury regarding Miss Lively's claim for emotional distress damages. Also, Miss Lively has identified the emotional distress damages she is seeking in her damages description, which she asserts is consistent with garden variety emotional distress damages. This is not a defined term for the jury and is a legal issue, not a factual one. Reputational harm is an element of non-economic damages recoverable under the FEHA. On the parties' conferral, defendants refuse to provide the basis for their position that Miss Lively has waived the right to claim reputational harm, notwithstanding the disclosure of reputational harm in Miss Lively's initial disclosures and expert reports. Miss Lively never maintained that she has sustained reputational harm only in connection with her defamation claim. Instead, as Miss Lively has long disclosed, she seeks reputational damages for the harm incurred from retaliatory public statements and those attributable to the retaliatory campaign. Defendant's position. Reputational harm related to the defamation is no longer part of the case, and plaintiff has waived her right to assert any additional reputational harm per defendant's motion in limine. The jury cannot be instructed that no standard exists for awarding emotional distress damages when Miss Lively has explicitly limited her claim to garden variety damages. Yeah, that's absolutely fair. I don't know what she's doing here. This is stupid. Contract damages. If you decide that Miss Lively has proved her claim against Ainsworth's movie for breach of contract, you must also decide how much money will reasonably compensate Miss Lively for the harm caused by the breach. This compensation is called damages. The purpose of such damages is to put Miss Lively in as good a position as she would have been if It Ends With Us movie had performed as promised. You see, and she's trying to say, well, there's no but for. That is the but for. But for It Ends With Us movie breaching this contract, this harm would not have happened to Miss Lively. She's literally saying to herself here, you know, in the way she's wording that is literally incorporating the but for test. But in the last video, you know, one of their positions was it's not necessary for a but for standard, which is higher than, and it's just like there is contract claim but for. To recover damages on this claim, Miss Lively must prove that when the contract was made, both parties knew or could have reasonably have seen that the harm was likely to occur in the ordinary course of events as a result of the breach of the contract. Miss Lively must also prove the amount of her damages according to the following instructions. She does not have to prove the exact amount of damages. You must not speculate or guess in awarding damages. Then we have general contract damages. Lively's proposed instruction. Miss Lively claims general damages for emotional distress when the express object of the contract is the mental and emotional well-being of one of the contracting parties. The breach of the contract may give rise to damages for mental suffering or emotional distress. Wayfarer don't have a proposed instruction. Let's look at their positions. Lively's position. Plaintiff maintains that an express object of the protections agreement was to ensure plaintiff's mental and emotional well-being, which the court already recognized is a basis to recover emotional distress damages under contract. Wayfarer's position. The express objection of the contract was not the mental and emotional well-being of Miss Lively. It doesn't say that. It does not say that. She is not entitled to emotional distress damages for breach of contract. Yeah, that's just ridiculous. Special contract damages. Lively's proposed instruction. Miss Lively also claims special damages in the form of lost acting, endorsement and speaking opportunities, and lost profits in the form of earnings associated with her brands, Betty B and Blake Brown. To recover for this harm, Miss Lively must prove that when the parties made the contract, It Ends With Us movie knew or reasonably should have known of the special circumstances leading to the harm. Defendant's proposed instruction. To recover for lost past earnings, lost future earnings, or lost profits under a breach of contract theory, Miss Lively must prove that when the contract was made, both parties knew or could reasonably have foreseen that the harm was likely to occur in the ordinary course of events as a result of the breach of the contract. Miss Lively must also prove that when the parties made the contract, It Ends With Us movie knew or reasonably should have known of any special circumstances leading to the harm. Lively's position. Plaintiff disagrees that the proposed language is misleading. This instruction is necessary to instruct the jury as to the basis for plaintiff's claim for special contract damages. Defendant's position. Defendant's instruction follows the CI language. Plaintiff's language is misleading. I think that's supposed to be misleadingly. Plaintiff's language misleadingly refers to lost earnings associated with her brands. Willful breach. Plaintiff's proposed instruction: one who willfully breaches a contract bears the risk as to the uncertainty or the difficulty of computing the amount of damages. Wayfarer do not have a proposed instruction. Lively's position: plaintiff maintains that this instruction is appropriate. Defendants have provided no authority otherwise. Wayfarer: this is not proper jury instruction. Straight to the point. No reduction of damages based on protected characteristic. In determining a reasonable amount of Miss Lively's lost earnings, you must not use race, ethnicity, or gender as a basis for reducing Miss Lively's lost earnings. They seem to agree on that. Another agreed one here: present cash value. Defendants claim that Miss Lively's future economic damages for loss of earnings, and lost profits, if any, should be reduced to present cash value. This is because money received now will, through investment, grow to a larger amount in the future. Present cash value is the amount of money that, if reasonably invested today, will provide Miss Lively with the amount of her future damages. Defendants must prove through expert testimony the present cash value of Miss Lively's future economic damages. It is up to you to decide the present cash value of Miss Lively's future economic damages in light of all the evidence presented by the parties. Use of present value tables. Use of Worksheet B and Table B to compute the present value of lost earnings and lost profits. 2. Determine the future years in which a future loss will occur. In column A, starting with the current year, enter each year through the last year that you determined a future loss will occur. 3. Determine the amount of plaintiff's future loss for lost earnings and lost profits for each year that you determine the loss will occur. Enter these future losses in column B on the worksheet. Enter 0 if no future loss occurs in a given year. 4. Select the interest rate that you decide based on the expert testimony that you have heard represents a reasonable rate of return on the money invested today over the number of years determined in step 2. Enter this rate in column C on the worksheet for each year that future loss amounts are entered in column B. So I'll continue, but the tables that they're referring to here are not here. They are, as you can see in highlight, they are to be inserted. They're not there yet. So I cannot explain it all to you, unfortunately. But I'll read it anyway, though. Select the appropriate present value factor from Table B for each year for which you have determined that a loss will occur. To locate this factor, use the number of years from column A on the worksheet in the interest rate in column C on the worksheet and find the number that is the intersection of the interest rate column and number of years row from the table. Right, so okay, so it's just using tables basically. I won't go. I won't go on for that because it's hard without pointing to the table and saying, right, this is what they're asking the jury to do. It's really hard to kind of explain that. Prejudgment interest. If you decide that Miss Lively is entitled to recover damages for past economic loss in one or more of the categories of damages that she claims, then you must decide whether she should also receive prejudgment interest on each item of loss in these categories. Prejudgment interest is the amount of interest the law provides to a plaintiff to compensate for the loss of the ability to use the funds. If prejudgment interest is awarded, it is computed from the date on which each loss was incurred until the date on which you sign your verdict. Whether Miss Lively should receive an award of prejudgment interest on all, some, or none of any past economic damages that you may award is within your discretion. If you award these damages to Miss Lively, you'll be asked to address prejudgment interest in the special verdict form. Okay. Mitigation of damages. Alright, Lively's proposed instruction. Wayfarer and Ainsworth's movie claim that if Miss Lively is entitled to damages, they should be reduced by the amount that Miss Lively could have earned from other employment. To succeed, Wayfarer and Ainsworth's movie must prove all of the following. 1. That employment substantially similar to Miss Lively's former job was available to her. I thought she had 4 things in production. I'll have to check IMDb, but I thought she had things in the works. 2. That Miss Lively failed to make reasonable efforts to seek this employment. And 3. The amount that Miss Lively could have earned from this employment. In deciding whether the employment was substantially similar, you should consider, among other factors, whether A. The nature of the work was different from Miss Lively's employment with It Ends With Us. B. The new position was substantially inferior to Miss Lively's former position. C. The salary, benefits, and hours of the job were similar to Miss Lively's former job. D. The new position required similar skills, background, and experience. E. The job responsibilities were similar. It's going to be really hard because really the only thing that Lively had, she had 2 movies where there were sequels. Obviously, one was A Simple Favor, and she did complete that sequel, Another Simple Favor. The other was It Ends With Us, because there would have been another film. It Starts With Us. That is now not going to happen. Other than that, though, the difficulty with this job and saying, well, she's lost opportunities, is that you audition, and it is out of Wayfarer's control. You know, who is putting Lively forward for jobs, who is pushing in the background to get her that job, and, you know, whether she is hired by the production studio for said job. And the thing is, when you look back at her resume, Gossip Girl was one of her first big things. I know it wasn't the first, but it was one of her first big things. Well, that was decades ago. She hasn't really done anything like huge since. You know, she's not what would be considered an A-list. She's an A-list because she's married to Ryan Reynolds. But on her own terms, for her own acting career, take away all of her connections and all of her dragons, Blake Lively as an actress, I would not say she is an A-list actress. So how do you... Well, she is an Amber Heard, I guess. And how do you calculate this? You know, because she kind of torpedoed It Starts With Us herself. Defendant's proposed instruction. If you decide defendants are responsible for the original harm under any theory, plaintiff is not entitled to recover damages for harm that defendants prove plaintiff could have avoided with reasonable efforts or expenditures. You should consider the reasonableness of plaintiff's efforts in light of the circumstances facing her at the time, including her ability to make the efforts or expenditures without undue risk or hardship. If plaintiff made reasonable efforts to avoid harm, then your award should include reasonable amounts that she spent for this purpose. Lively's position. Plaintiff maintains that the appropriate instruction with respect to FEHA damages is CACI 3963 rather than CACI 3930, which, as stated in the directions for use, applies to personal injury cases and is thus inapplicable to plaintiff's employment cause of action. Plaintiff disagrees that this instruction is only applicable to cases involving terminations, and as set forth above, plaintiff does not seek damages related to lost wages or salary. That FEHA permits make whole damages does not convert FEHA damages to tort damages. In addition, CACI 3930 misstates the standard for mitigation under FEHA. Defendants cite no authority to support their position. Defendant's position. Plaintiff's proposed instruction only applies in cases where an employee was terminated and seeks damages related to their wages or salary. Ms. Lively seeks lost profits and lost earnings in the form of hypothetical acting opportunities. Exactly, they're hypothetical, which are more general tort damages requiring the more general mitigation instruction. Defendants are also entitled to instruct on mitigation for breach of contract in any event. Arguments of counsel, not evidence of damages. The arguments of attorneys are not evidence of damages. Your award must be based on your reasoned judgment applied to the testimony of the witnesses and the other evidence that has been admitted during trial. So that's just saying, like, any arguments that the attorneys make, the opening statement, the closing statements, they are not evidence, and they're not evidence especially of damages. So that's telling the jury, just concentrate and, decide your verdict and the award on the testimony of witnesses and the other evidence. Jurors are not to consider attorney fees in court's costs. You must not consider or include as part of any award attorney's fees or expenses that the parties incurred in bringing or defending this lawsuit. Punitive damages. If you decide that Wayfarer Studios, the Ainsworth movie, or Tag's conduct caused Miss Lively's harm, you must decide whether that conduct justifies an award of punitive damages. The amount, if any, of punitive damages will be an issue decided later. At this time, you must decide whether Miss Lively has proved that Wayfarer Studios, Ainsworth movie, or Tag's engaged in the conduct with malice, oppression, or fraud. To do this, Miss Lively must prove one of the following by clear and convincing evidence. 1. That the conduct constituting malice, oppression, or fraud was committed by one or more officers, directors, or managing agents of Wayfarer, Ainsworth movie, or Tag, who acted on behalf of Wayfarer, Ainsworth movie, or Tag. 2. That the conduct constituting malice, oppression, or fraud was authorized by one or more officers, directors, or managing agents of Wayfarer, Ainsworth movie, or Tag. Or 3. That one or more officers, directors, or managing agents of Wayfarer, Ainsworth movie, or Tag knew of the conduct constituting malice, oppression, or fraud and adopted or approved that conduct after it occurred. So we're getting into some definitions now. Malice means that Wayfarer, Ainsworth movie, or Tag acted with intent to cause injury, or that Wayfarer, Ainsworth movie, or Tag, I'm just going to say Wayfarer now going forward, or that Wayfarer's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A person acts with knowing disregard when the person is aware of the probable dangerous consequences of the defendant's conduct and deliberately fails to avoid these consequences. Oppression means that Wayfarer's conduct was despicable and subjected Miss Lively to cruel and unjust hardship in knowing disregard of her rights. Cruel and unjust hardship. That's going to be a bench that she's just not going to be able to get to. That's just ridiculous. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that Wayfarer Studios intentionally misrepresented or concealed a material fact and did so intending to harm Miss Lively. An employee is a managing agent if the employee exercises substantial independent authority and judgment in corporate decision-making, such that the employee's decisions ultimately determine corporate policy. Burden of proof, clear and convincing. Lively's proposed instruction. For liability for punitive damages, the burden of proof is clear and convincing evidence, which is a higher burden of proof than preponderance of the evidence. This means Miss Lively must persuade you that it is highly probable that the facts as to punitive damages liability are true. Defendant's proposed instruction. Certain facts must be found by clear and convincing evidence. Clear and convincing evidence is a more exacting standard of proof than a preponderance of the evidence, where you need believe only that a party's claim is more likely true than not. On the other hand, clear and convincing evidence is not as high a standard as the burden of proof applied in criminal cases beyond a reasonable doubt. Clear and convincing evidence leaves no real substantial doubt in your mind. It is proof that establishes in your mind not only that the proposition at issue is probably true, but also that it is highly probably true. For evidence to be clear and convincing, the witnesses must be found credible, the facts to which they testify must be distinctly remembered, and the testimony must be so clear, direct, weighty, and convincing that you can reach a clear conviction without hesitancy of the truth of the precise facts in issue. Although this is a significant burden of proof, it is not necessary that the evidence be that the evidence uncontradicted as long as the evidence leads you to a clear conviction of its truth. Lively's position. The parties disagree with respect to the language of the instruction and the sequence in which it should be given. Plaintiff maintains that the clear and convincing instruction should follow the language of the CACI 201. Relying on federal case law, defendant's proposed instruction seeks to impose a much higher burden than applies. Plaintiff also asserts that the instruction should be given in connection with instructing the jury on punitive damages rather than as part of the court's general instructions related to the burden of proof. This is especially important where, as here, Miss Lively's punitive damages claim is the only claim that uses a clear and convincing standard. Including such instruction at the outset of the case may therefore risk the jury apply a clear and convincing burden where not required by law. Sequencing the instruction in connection with punitive damages, on the other hand, would effectively limit application of the higher burden only where appropriate and also moot defendants' concerns about instructing the jury as to punitive damages at the outset of the case. Defendant's position. Defendant asserts the clear and convincing instruction that should be administered in connection with the burden of proof instruction. Defendants are entitled to an instruction on clear and convincing evidence as the standard for certain issues. For example, whether defendants engaged in conduct with malice must be proved by that standard. We've only got a few more pages and we're going into the final instructions. Right to see and hear exhibits and testimony, communications with court. You are now about to go into the jury room to begin your deliberations. Before you do that, I will give you a few final instructions. The parties have prepared a list of the exhibits that were received, listed by exhibit number. If you want a particular exhibit or you want any testimony sent or read back to you, you may request that. Any communication with the court should be made in writing, signed by your foreperson and given to the court security officer, whom, as in all cases, I will swear to ensure that your deliberations may take place uninterrupted. Please remember that it is not always easy to locate what you might want, so be as specific as you possibly can. If you want testimony read back to you, please try to be as specific as you possibly can, because the court reporter will have to look through the transcript and the parties will have to agree on what portions of testimony may be called for in response to your request. And if they disagree, I must resolve those disagreements. If you want any further explanation of the law as I've explained it to you, you may also request that from the court. If there is any doubt or question about the meaning of any part of the instructions that I have given you during this trial, you should not hesitate to send me a note asking for clarification or for further explanation. It is very important that you do not communicate with anyone outside the jury room about your deliberations or anything touching this case. There is only one exception to this rule. If it becomes necessary during your deliberations to communicate with me, to request testimony, or to request clarification on the law, you should send a note to me in writing, signed by your foreperson, and given to one of the court security officers or to my deputy, Mr. Fishman. No member of the jury should ever attempt to communicate with me except by signed writing, and I will never communicate with a member of the jury on any subject touching on the merits of the case, other than in writing or orally here in open court. If you send any notes to the court, do not disclose anything about your deliberations. Specifically, do not disclose to anyone, not even to me, how the jury stands, numerically or otherwise, until you have reached a unanimous verdict or have been discharged. Notes. Many of you have taken notes periodically throughout this trial. You should not show your notes to or discuss your notes with any other jurors during your deliberations. Any notes you have taken are to be used solely to assist you. The fact that a particular juror has taken notes entitles that juror's views to no greater weight than those of any other juror. I want to emphasize to you, as you are about to begin your deliberations, that notes are simply an aid to memory. Notes that any of you may have made may not be given any greater weight or influence in determination of the case than the recollections or impressions of other jurors, whether from notes or memory, with respect to the evidence presented, or what conclusions, if any, should be drawn from such evidence. Any difference between a juror's recollection and another juror's notes should be settled by asking to have the court reporter read back the transcript, for it is the court record rather than any juror's notes upon which the jury must base its determination of the facts and its verdict. Duty to deliberate unanimous verdict. You will now retire to decide the questions I have described to you. For Miss Lively to prevail on the questions that you must answer, she must sustain her burden of proof. Your verdict on each question must be unanimous. Each juror is entitled to his or her opinion, but you are required to exchange views with your fellow jurors. This is the very essence of jury deliberation. It is your duty to discuss the evidence. If you have a point of view and after reasoning with the other jurors it appears that your own judgment is open to question, then of course you should not hesitate in yielding your original point of view if you are convinced that the opposite point of view is really one that satisfies your judgment and conscience. You are not to give up a point of view, however, that you contentiously believe in simply because you are outnumbered or outweighed. You should vote with the others only if you are convinced on the evidence, the facts, and the law that is the correct way to decide the case. You are not to discuss the case until all jurors are present. 4 or 5 jurors together is only a gathering of individuals. Only when all the jurors are present do you constitute a jury, and only then may you deliberate. Selecting a foreperson and the foreperson's duties. The first thing you should do when you retire to deliberate is to take a vote to select one of you to sit as your foreperson. The foreperson will send out any notes, and when jury has reached a verdict, he or she will notify the court security officer that the jury has reached a verdict, and when you come into open court, the foreperson will be asked to state what the verdict is. Verdict form and return of verdict. Once you have made your verdict, you will record your decisions in a verdict form which I have prepared for you, which we have already been through in a previous video. I think it was the first one actually, the jury instructions, jury instructions video. You should also proceed through the questions in the order in which they are listed, following the instructions on that form. Once you have completed the form, the foreperson should then fill in the verdict sheet and date it, and each of you should sign it. The foreperson should then give a note to the court security officer outside your door stating that you have reached a verdict. Do not specify what the verdict is in your note. I will stress that each of you must be in agreement with the verdict that is announced in court. Once your verdict is announced by your foreperson in open court and officially recorded, it cannot ordinarily be revoked. Oath. I remind you that you took an oath to render judgment impartially and fairly, without prejudice or sympathy, and without fear, solely upon the evidence in the case and the applicable law. Your oath sums up your duty. I know that you will do your duty and reach a just and true verdict. exceptions. I will ask you to remain seated while I confer with the attorneys to see if there are any additional instructions that they would like to have given to you, or if there is anything I may not have covered. In this regard, I ask you not to discuss the case while seated in the box, because the case has not yet been formally submitted to you. Members of the jury, that concludes my instructions to you. You may now retire to the jury room and begin this phase of your deliberations. As a matter of business, please select a full person and send me a note, signed, dated, and timed, through the court security officer or my deputy, Mr. Fishman, telling me who you have selected as your full person. And there we go. We're at the end. That's very long-winded jury instructions. Yeah, that was a lot. But it's interesting to see, like before this becomes the final thing, how it all gets formulated, the various proposals, and looking at the little differences between them from what Blake Lively's team are putting forward, what Wayfarer's team are putting forward, and just look at who's been entirely unreasonable, Blake Lively, and who is being quite measured and sticking within the law. I hope you find these kind of videos interesting. I hope they're helpful to explain some of this this is where we're seeing some of the background work going on, as we're kind of in this home stretch now. Is just a little over a month till we get to trial. So for me, I love this part. I think it's it kind of sets the scene almost for what we can expect, because don't forget, this one is not going to be televised, so we're going to have to rely on any content creators who are able to go to court, but we won't hear from them throughout the day because there'll be no phones. So we might hear during breaks, we might hear late after, so we could be sitting waiting hours. There's obviously Matthew, court reporter. I think he might be tweeting. But for me, it's nice to see this kind of, we can set the scene for what it's likely to look like, at the end, what the jury are going to hear, what instructions they're going to be given, motions in limine, what experts, if any, are going to be, excluded. And also, will we even have anything to go to court with in the end? Will the motion for judgment on pleadings and the motion for summary judgment, will they be successful? It's likely going to just have a shot on this one contract claim, which again is piss poor. Yeah, but this has been real fun. This is where all the work of the last year is now starting to come together, and really what has gone on the docket already does not matter, because that was just to boil down the claims. This is now actually putting together what is going to go before the jury at trial. I hope you find it as interesting as I do. As always, if there's any questions, please do just leave them in the comments. I'll always try and answer them. I always respond one way or another, but if I can answer them, I will. I've got a lot of stuff still to get through though, because I've got all the Daubert motions before we get the drop of all the oppositions on Friday. So tomorrow I'm going to try and power through all the Daubert motions, because there are a lot and they're quite lengthy motions as well. So yeah, we'll get through that. And so there may be a bit of a delay in me responding to comments. I will get to them, I always do, but yeah, it's just a little bit of a lag at the moment because there's just so much going on. I'm still trying to get through. All right, guys, take care.